Well, good morning and welcome. It's wonderful for us to be getting back to face-to-face sessions. From my perspective, it's a bit tiring talking to a camera and getting no audience reaction. So welcome today to the session. The session is in relation to workplaces and challenges that you as employers are facing. Must be feeling at the moment somewhat under siege, but we're here to help and give you some tips as to how you might have some solutions in relation to some of the challenges you're facing. By way of introduction, what I'll be talking about today is some of the long-term trends that we're seeing in workplaces, how that plays into the current Fair Work reforms that have been recently introduced, as well as future reforms and what we're seeing in relation to the employment claim trends. In terms of our view is that in terms of those long-term trends, what we're seeing is a greater individualisation of the workforce, which in our view is inconsistent with some of the reforms we're currently seeing from the current National Labor government. To talk about first up, in terms of the Australian workforce, and just a snapshot as to where we are. We've currently got a population of 25 million, and that's predicted to grow to 35 billion by 2050. Australia's workforce is about 13.7 million, and we currently have an employment to population ratio of about 64%, which is the highest ever. What that means is we've got more people working than ever. Australia had about 490,000 job seekers in December 2022. There's been an increase in that in the January figures by about 22,000. But despite that, the unemployment rate is, as we know, remaining low. It's ticked up from 3.5% in December to 3.7% in January. But that, as we know, is a historically low figure. Interest rates are clearly having their impact in relation to not only general economic conditions, but also an uptick in terms of the unemployment rate. In terms of some of the long-term trends, we've seen a clear long-term trend towards what I describe as the individualisation of the private sector workforce. Individualisation rather than collectivism has become the norm. And this is evidenced most starkly by union density figures in Australia. So if we go back to the 1970s, union density was as high as 50%. In 1992, that had dropped back to about 40%. Today, though, there's a total of 1.5 million people, or about 14.3% of our workforce, that are members of a trade union. Now, these are mainly in sectors including education, public administration and healthcare. Interestingly, women are the majority of union members in the public sector, whereas men are the majority in the private sector. In terms of numbers, 8%, only 8% of workers in the private sector are a member of the union. So it's very much, unionism today is very much a public sector phenomenon. What's probably most concerning for the union movement is only 5% of workers aged between 15 and 19 are members of trade union. However, despite that, as we know, trade union movement still has a great deal of influence in our workforces. Australia's federal workplace laws continue to recognise the trade union movement, providing with rights in important areas such as right of entry, bargaining for enterprise agreements, and right of appearance before the Commission. The effect of the individualisation of the private sector is a more direct relationship between an employer and their workforce. Collective industrial action is no longer a part of the industrial landscape like it was in the 1970s. Collective agreements in the form of enterprise agreements have become rare, and in my view will continue to be rare despite recent changes. And there's a greater reliance on the safety net, that is modern awards, less formal contractual arrangements negotiated directly between an employer and their workforce, and an increase in the number of independent workers, in particular independent contractors, which are used by organisations such as Uber. Turning now to the Fair Work reforms, which as I've intimated, seem to be in contrast to some of these long-term trends that we've been seeing. So in late May last year, the Labor Party formed government at the national level under Anthony Albanese. The party came to power on an interventionist platform, the likes of which has not seen at a federal level for many decades. In the area of industrial relations, Labor promised under its industrial relations policy that it took the election to introduce greater regulation, in particular to address its concern about insecure work. A regular target of the union movement, insecure work, has of course been the subject of seminal High Court decisions focused on casual workers and independent contractor workers in recent years. Labor, with the support of the Greens, was able to pass its bill to amend the Fair Work laws known as the Secure Jobs Better Pay Bill 2022 late last year. These reforms are some of the most significant permanent changes to the federal industrial relations system since the introduction of the Fair Work laws 2000. And I deliberately use the word permanent because, of course, we did see the JobKeeper reforms to the Fair Work laws earlier, which were obviously significant. Significantly, each aspect of the bill will commence on a particular date. That is, curiously, not all of the legislation starts at the same point, and there's a period of about 12 months over which different changes under the bill will commence. So in your packs today, what you will see is a one-page document which sets out the dates of some of the key changes under the reforms that you can take away. Turning now to some of the big picture changes in the area of construction, bargaining and enterprise agreements. Construction, as we know, coming off the back of the Royal Commission that was set up during the Howard era, had some specific legislation directed towards building participants. The reason that was thought necessary, as we would all know, is that there was certain conduct in that industry which was seen to be having a significant negative impact on the Australian industry. So there was legislation that was introduced, and the Australian Building and Construction Commissioner was established to regulate the industry. The ABCC had specific powers under its own Act and also the Fair Work Act. What Labor has done since late last year, it has abolished the ABCC and has given the powers that the ABCC had to regulate the industry to the Fair Work Ombudsman. So that's become the workplace regulator in the industry. So matters such as unlawful industrial action, coercion, adverse action and the like will now be dealt with under the Fair Work Act rather than specific legislation set up for the building industry. The abolition of the ABCC has already occurred, so the industry now falls back to the Fair Work Act, and that's the act under which it is to comply, and the regulator is now the Fair Work Ombudsman. That's a significant change. Some of the state governments have indicated an intention to look at setting up their own state-based ABCC bodies. So last week we had the New South Wales government come out and indicate that they were looking at that as an option in the run-up to the election. We haven't heard the position in South Australia, but there have been some noises made about that possibility when the CFMU, of course, was taken over by our Victorian brothers. So that is a space that we may well see some change. In terms of the area of bargaining, a lot of the discussion in the media has been focused in relation to the possibility of multi-employer bargaining. And some of the barriers to that have been removed. In effect, what that enables a union and workforce to do is bargain collectively across multiple employers. My view is, particularly with the low membership in the private sector of union members, that that's not really something that's going to get off the ground. because it seems to me you need large numbers of union members in each of those work sites to be able to get that off the ground. So it's going to be a large one to be able to pull off. My view is there's some other changes that are more significant, particularly for employers in South Australia. One of those is in relation to the issue of commencement of bargaining itself. So before the reforms, an employer may commence the agreement making process, that is bargaining on their own initiative. A variation of this might be where the employer agrees to bargain in response to a request from the workforce or union. The other way in which it could happen is against the will of the employer. This could happen in a rare situation where a union might make an application to the Commission and there would need to be a vote of the workforce, and the majority of the workforce would in effect need to vote in favour of commencing the bargaining process. This was called a majority support determination. It still exists under the Fair Work laws, but they were the mechanisms under which bargaining could commence. All of that was reasonably difficult. As you can appreciate, again, because of the low numbers of union density across workforces, you found that MSDs were fairly rare. The other part of the process, as we would know, is the notice of employee representational rights that needed to be provided to employees or the workforce as part of the bargaining process. And an employee may, through that process, appoint a bargaining representative, that is a member of a union, to assist them in relation to bargaining. A key element of the reforms then is that there is no need for an NERR to be issued to commence bargaining for a replacement enterprise agreement. And a replacement agreement is one that has a nominal expiry date within the last 5 years and covers a substantially similar scope of employees. So basically, a replacement agreement would be replacing the existing agreement. In this case, bargaining may commence on a written request for an employee bargaining from an employee bargaining representative. That is a significant change. This removes an opportunity for an employer to resist bargaining in the case of an expired enterprise agreement. Now, that's a significant change which enables unions and the workforce to commence bargaining through a fairly simple process, and then the employer is locked into that bargaining process and obviously got the good faith bargaining obligations under the Act. So that, in my view, one of those significant changes that hasn't necessarily been picked up by the media at this stage, and certainly for employers in Australia, could have a significant impact.
Is that a once it's expired only, or?
Yes, so it needs to have, that's correct. So it needs to be expired, and it needs to be expired within the last 5 years. So that process doesn't apply to old agreements.
It's just one.
So the change in relation to enterprise agreements. So the biggest changes under the reforms in relation to enterprise agreements relate to the requirements for approval of an agreement, the ability to unilaterally terminate such agreements, and changes to the Better Off Overall test. In terms of the procedural requirements, the reforms replace the current prescriptive pre-approval requirements for enterprise agreements, such as issuing a NERR and strict timeframes for key steps in the voting process. This has been replaced by a broader requirement that the Commission be satisfied that employees genuinely agreed to the agreement. Now, this is a significant change. So instead of the Commission being required to look at every step of the procedural process, pretty much like a tick and click exercise, and if you haven't done one of those, the agreement doesn't get approved, what the Commission can do is take a broader test and look at, have the employees genuinely agreed with this agreement itself. So it's a broader test. That has obviously been welcomed by employers, unions and workforces alike, because there were too many of these agreements that weren't getting approved for minor procedural issues. The other significant change, again, probably hasn't been picked up by the media that much, is in relation to termination requirements in relation to enterprise agreements. Previously, the test was that the Commission need only be satisfied that terminating an agreement which has passed its nominal expiry date, is not contrary to the public interest and take into account the views of the parties to the agreement. Now, if it's satisfied under that test, it could then terminate the agreement. And there was a decision going back a few years now where Queensland Rail was privatised and the new private owners sought to terminate the agreements that applied to the workforce up there, and they were able to convince the Commission it was appropriate to do so on the basis of the change in the nature of their business. So instead of being a public sector Queensland Rail, they became a private operator, and they were able to convince the Commission to terminate their agreements. That was seen as a bit of a watershed decision, and since that time the Commission has been a bit more relaxed about terminating these agreements, much to the annoyance of the union movement. So what these reforms do is seek to address that particular concern. It now requires the Commission to instead be satisfied of one of the following before terminating an existing agreement. That is, the continued operation of the agreement would be unfair to the employees it covers. The agreement does not and is not likely to cover any employees. The continued operation of the agreement would pose a significant threat to the viability of the business, and the employer gives a guarantee that it will preserve termination entitlements under the agreement. So you can see in order to satisfy one of those requirements is a pretty hard test. So what that means is that what we're expecting in the future is there's going to be less ability to terminate agreements after they expire. And it's quite often used by employers as part of a negotiation tactic, because obviously the threat is you fall back to the bond award if the agreement is terminated. So this is a significant change which has already come into effect, as you'll see from the document in your pack. The other changes in relation to the boot and the reforms make change to the boot to address some of the concerns that have been raised about its practical application by the Commission. In particular, the changes that require the Commission to undertake the boot as a global assessment instead of a line-by-line comparison. And this really is to address the Coles agreement situation where, as a large business, what the Commission did was a sort of a line-by-line comparison, checking all types of employees in different locations, and came to the conclusion that a part-time employee at one of their stores in North Queensland was disadvantaged, and therefore the whole agreement failed to boot. So what the change is really about is looking at a global assessment and seeing if overall the employees are better off. This is a significant change. Again, this change has been welcomed particularly by employers because they see that as an opportunity to get their agreements approved with some greater certainty in the future. Those changes won't commence until the middle of this year. In terms of some of the other reforms, I've sort of picked out pay secrecy, flexible work and fixed term contracts. These are ones that really are going to apply to most employers, including those based here in South Australia. So they're really changes to the employment relationship. So in terms of those, the job security one, the way in which Labor has achieved that has been by including job security as a fair work objective. So in the Act itself, there's a list of objectives, which include such things as providing workplace relations laws that are fair to working Australians, ensuring a guaranteed safety net, assisting employees to balance their work and family responsibilities, fairness of representation of work, productivity. So these objectives now have the objective of job security. Now, what's going to be interesting about that is, and I should add that when the Commission is carrying out its functions and making its decisions, it's got to consider the objects. So potentially in relation to the job security, as a real practical example, is when they're considering making changes to modern awards, they will need to consider this objective of job security. So what you can expect in the future is the unions will probably be pushing for this issue of job security to be dealt with in awards. It might be things such as restrictions on the use of casuals and so forth. So we can expect some sort of a debate about that in the future, but that's something to certainly watch for, because that's the practical effect of including that as a fair work objective in the Act. The other significant change which affects all employers is, of course, this area of pay secrecy. Now, certainly in my experience, when I first started at a law firm, this firm I should say, I had a pay secrecy clause in my contract, and it's a fairly common term that can be found in contracts of employment. The clause will generally provide that an employee's remuneration is confidential and prohibits them from discussing it with anybody, including particular employees of the organisation in which they work. Breaches of those types of clauses generally enable an employer to take disciplinary action, including up to termination of employment. What the reforms do is they now make it a workplace right for employees to disclose, not disclose, information regarding their remuneration and terms and conditions of employment required to calculate their remuneration. So by making this a workplace right, it means that employees are protected from having adverse action taken against them from making such disclosures, so you obviously can't discipline. Further, employers are now entitled to make general protections claims if their employer takes adverse action against them, having exercised that workplace right. And as we know, that's a breach of the Act, which is quite a significant breach. So what that means for employers is we need to review our contracts of employment, make sure we don't have any pay secrecy provisions, that we're updating our contracts for any more reporting that's happening in the future. And those changes are already in place.
So if that applies to high income earners.
I understood that it did. I know there was some debate about that issue, but I understood that it did apply to high income earners. In terms of flexible work, I've taken a photograph of myself on the 20th of March 2020, which was the start of COVID, and I was part of the team that worked from home at that particular point in time. It's certainly something that we've all experienced in the last 3 years, and there has been a significant uptake in terms of working from home. It's been estimated that over half of workers in the finance industry and public administration have worked from home over the last 3 years. And this has led to the increase in the use of technology in our workplaces. In our industry in particular, we're much greater at using phone and Teams and the like. And this has really changed the culture in terms of personal attendances at court, for instance. So a lot of our directions hearings aren't done face-to-face anymore in the courtroom environment, that they're done over the phone or through Teams or some other form of technology. And look, what we're finding is employers, with the current labour shortages in particular, having to accommodate this desire of workers to work from home. So in terms of what Labor has done about this issue in the Fair Work reforms, it's amended the rules relating to requests for flexible work arrangements and has introduced new provisions empowering the Commission to resolve disputes regarding such requests, which is a significant change. In terms of the scope of these flexible requests, the rights for it have been increased to include situations of family and domestic violence. In terms of the obligation itself, the reforms have changed the obligations that are imposed upon employers in relation to these requests. So what an employer must do now is meet with the employee to discuss their flexible work request. Where the employer intends to refuse the request, agree upon alternative changes to working arrangements and note the agreed changes in the request. Or if the employee still intends to refuse the request, outline the employer's reasonable business grounds for refusal, including addressing some specific issues, such as changes to working arrangements, and that there are no changes the employer could accommodate to accommodate the employee's circumstances. Now, this is probably what a lot of employers were doing as a matter of best practice anyway, but it's now been codified in the Act itself. Probably the more significant change, in my view, is in relation to what happens when there is a dispute. So for the first time, the Act now introduces a dispute resolution mechanism for circumstances where an employer has refused such a request, not provided a written response to a request, and the parties are unable to resolve the dispute through discussion at the workplace level. In these circumstances, what the new provisions allow for is a flexible working arrangement dispute to be notified to the Commission. There is an ability for conciliation to take place in relation to that particular dispute, but if that is not successful, the Commission now has the power to deal with the dispute itself, including making decisions such as an order that an employer be taken to have refused a flexible work request where the employer has not responded within the prescribed 21 days, or where the employer has refused the request, an order that it would be appropriate for the grounds on which the employer refused to be reasonable business grounds, or an order that the employer provide the employee with a written response to their flexible work request under the Act. So these orders can't be obviously consistent with the Act, and they are due to start later on this year. And they're obviously some significant changes because it's empowering the Commission to be involved in this process in a more direct way than it has been in the past. So clearly our arrangements need to be reviewed, and employers need to be on top of being able to respond within the timeframes to such requests, and also considering appropriate business grounds if there is going to be a refusal of such a request in the future. The other significant change, which has probably got a little bit more media traction, is in relation to fixed term contracts. This is another area that's been a target of what Labor has described as insecure work. So what the reforms do is introduce provisions into the Act that limit the use of fixed term contracts for the same role to 2 consecutive contracts or a maximum duration of 2 years. So effectively what it does is puts a limit on fixed term contracts to that period. Interestingly, it also has provisions similar to the casual permanent provisions, which enable for the conversion of fixed term contracts to permanent employment contracts in certain circumstances. The prohibitions and regulations apply to both fixed terms and outer limit contracts being those fixed term contracts that have got a termination provision in it. So those contracts also are regulated by these new provisions. There are certain exceptions, and I can see a lot of disputes before industrial tribunals taking place in relation to these exceptions. So just to quickly go through those, they include to perform only a distinct and identifiable task involving specialised skills, to perform essential work during a peak demand period, training arrangements, an employee who's a high income threshold earner. So anyone over that $162,000 is not guaranteed that you can still have on fixed term arrangement. Appointment to a governance position that is time limited, something that is wholly or partly government funded. This is interesting. I think what that's saying is that the government's going to set its own rules. So if you've got a government funded position, you can continue to use these rolling fixed term contracts, which, as a lot of us would know, this has been a standard practice that's been used in the state public sector for a long time, particularly in areas such as education. So the government gets to continue to use their approach, but it's the private sector that doesn't. So the other requirement, the other exception is where a modern award permits the use of fixed term contracts, but it's unlikely to see that happening in circumstances where, as we've discussed, the objectives of the Act have just changed, and job security is one of those objectives. So it would seem to be inconsistent with that you have a modern award that has the ability to have the use of fixed term contracts beyond 2 years. So employers will now be required to comply with these requirements. These requirements will start later on this year in December. And when they do start, there's obviously going to be restrictions on the extended use of fixed term contracts. So employers will need to think about other arrangements in terms of engagement of fixed term employees on a longer term basis. Yeah, so I think the effect of that would be that if you're entering into one after the 7th of December, you've got 2 years from that point, if it makes sense. 7th of December is the date. Yeah, so if you've done it in October or November, I suspect you've probably got a grace period. So the 2 years starts from the 7th of December. So might be able to get 2 years and 2 months if that makes sense under that arrangement. Okay, so Some of the other significant changes, these are directed towards women, are equal pay and sexual harassment. So in relation to the issue of equal pay, what the Fair Work laws have traditionally allowed the Commission to do is to make a determination varying what the award minimum wages if they are satisfied by work value reasons to do so, which relates to any of the following: the nature of the work, the level of the skill or responsibility involved in doing the work, or the conditions under which the work is done. And the intention of this provision was to ensure the Commission could determine a wage floor for work of equal and comparable value. And we've seen in recent times the Commission get involved in some work value cases where it has increased wages based on large numbers of women in particular sectors. The reforms enable the Commission to make such a determination on its own initiative, so it now doesn't need to wait for the union to bring such a matter before it, and they provide that the Commission can consider work value reasons must be free of assumptions based on gender and include consideration of whether historically the work has been undervalued because of assumptions based on gender. So it's got to specifically consider those issues in relation to any work value cases that come before it now. I think it's pretty clear in terms of changing the aims and how the Commission shall deal with those matters, that will achieve the aim of a more efficient mechanism by which to close the gender gap in certain industries in the future. So it certainly makes it easier for the Commission to come to the conclusion that there is a gender gap and that needs to be closed. So that's a significant change in terms of to the Act, and we'll see that through some changes, no doubt, to some awards in future years. The other area of sexual harassment, we all know that sexual harassment has been prohibited under direct sexual harassment and discrimination at both state and federal law for a number of years. What's significant about the change here is that sexual harassment is now prohibited under the Fair Work Act. So that's the significant change. And what the reforms do is introduce this prohibition in relation to the workplace, and the protection extends to all workers, which is defined in a similar way to the Work Health and Safety Act. So the protection is to employees, contractors, subcontractors, outworkers. So we're going beyond just a direct employment relationship, much like the Work Health and Safety Act goes. It's a much broader test of who a worker is. So employers need to ensure that in terms of the issue of sexual harassment, it's not just your employees you're having to protect, but also contractors and others. Interestingly, there's also protection to prospective workers, and the other significant change is in relation to dispute resolution. Once again, the reforms enable the Commission to deal with sexual harassment. And just as an aside, you can see why it was that the government's been appointing a number of members to the Commission in recent times, because you can see a lot of extra work that the Commission will be doing in relation to these reforms. So in relation to this particular area, what the Commission is empowered to do is to provide for mechanisms for workers to seek a stop sexual harassment order and future harassment, and deal with a dispute and ordering compensation to remedy past harm caused by sexual harassment through mediation and conciliation. So what you're doing is effectively you're setting up the Commission as the body by which you can actually make sexual harassment complaints. Previously, as we know, they've been dealt with by state or federal discrimination bodies. My personal experience of those bodies is they've been quite slow in terms of the way in which they deal with matters. So anyone who's dealt with a sexual harassment or discrimination complaint will know that it's a very time-consuming process. The Commission works in a very different way. It works very quickly and can be expected to provide a quick, cheap and efficient remedy in relation to sexual harassment in the future. So this is a very significant change. The other significant part of it is that applications in relation to sexual harassment don't need to be made by an individual. They can be made by multiple agreed persons as well as by a union, as opposed to a single individual. And this again is a significant change because it enables people who as a group feel that they've been harassed by a particular individual to make a joint application permission. As I say, from a practical point of view, that really is a significant change. And a lot of sexual harassment complaints that I've dealt with in my experience, it's quite often the case that the person who's bringing the application is saying this person has been harassing others. Now those people will actually be part of the application, which is a really significant change, and will enable the Commission to deal with one individual who might be harassing more than one person. Consistent with that, separately, late last year, the Labor government also introduced some changes to the Sexual Discrimination Act. These changes impose a positive duty on an employer or a PCVU, using that language under the Work Health and Safety Act, to take reasonable and proportionate measures to eliminate some specified forms of unlawful sex discrimination. They include sex discrimination, sexual and sex-based harassment, hostile work environments, and victimisation. So what these new requirements will require is that measures are taken to prevent conduct being engaged in by duty holders, employees, workers, agents, and third parties. In particular, employers will need to make sure they're taking positive steps to make sure these acts don't occur at their workplace. In terms of powers, the Australian Human Rights Commission will be empowered to monitor and assess compliance with this positive duty by employers. Powers that they have under the Sexual Discrimination Act include options to conduct inquiries into a person's compliance with the positive duty, give a compliance notice specifying the action that a person must take or refrain from taking to address their non-compliance, and apply to the Federal Court for an order to direct compliance, and also require, and they can enter into enforceable undertakings, much like the Safe Work recommended here in this state in relation to safety issues. The government has considerably increased funding for the AHRC to enable it to monitor compliance with this positive duty. These changes that were introduced into Parliament passed last year, there's been a 12-month grace period such that those changes will commence in December of this year. But it's obviously a focus of the government at the moment, and will lead to employers ensuring that they've got policies in place, providing appropriate training and doing everything they can do to ensure they're complying with this positive obligation. The other area that is something the government is focused on, and looks as though this is going to be part of the second tranche of reforms to the Fair Work Act, is the issue of wage theft. Now, this has been an issue that's been around for some time. Back in 2019, some of us might remember it became somewhat of a national issue off the back of punishment that was meted out to celebrity chef George Columbaris. His business empire was involved in underpayment of about $8 million. And the Fair Work Ombudsman at that time entered into an enforceable undertaking, which involved a fine of $200,000 and Columbaris's agreement to do some speaking engagements for the Fair Work Ombudsman. At the time, there was a bit of uproar about that punishment. Even the Morrison federal government at the time was forced to acknowledge and agree what the public had already determined, namely that the fine handed out over systemic underpayment of its workforce was clearly light. And in response to that, you might remember that some states, in particular Victoria, passed wage theft laws that criminalised non-payment of minimum entitlements. The Morrison federal government did seek to introduce wage theft provisions in the Fair Work Act, though these did not pass Parliament. The only part of that bill that passed, you might remember, was those in relation to the issue of casual employment. Those laws had proposed a new criminal offence where an employer who dishonestly engages in a deliberate and systemic pattern of underpaying one or more employees of their business with penalties of up to 4 years of imprisonment. And the way in which they calculate the penalty for bigger employers was to impose fines based on 2 times the benefit obtained or up to 3 times the serious breaches. So what that meant is if there's an underpayment of $10,000, then the fine would be 20. So if you apply that to Colin Barris's situation, if it was, say, an underpayment of 8 million, the fine would be 16 million. So that was the approach. I mention this because Labor has recently announced that they will seek the introduction of wage theft provisions at a federal level in their second tranche of changes to the Fair Work Act. We don't know exactly when that's going to be, but my expectation would be is that that would be in the next 6 months. They clearly have the support of the Greens for these changes. So they have the numbers in the upper house. So you expect them to push forward with these changes, and it may well be that they get bipartisan support in relation to these proposed changes. The other area I wanted to touch upon in terms of the future is in the area of safety. So in South Australia, Labor has prepared a draft bill, the Work Health and Safety Industrial Manslaughter Amendment Bill, which seeks to introduce industrial manslaughter as a criminal offence. Key elements of this bill include the following, namely the industrial manslaughter offence, and that will apply where a person has been either reckless or grossly negligent in conduct which breaches a work health and safety duty and which results in the death of an individual. Importantly, in relation to that, it seems to me it doesn't need to be a deliberate act. So what we're talking about is negligence, not a deliberate act. And in that situation, the offence will apply to both PCBUs and officers of a PCBU. In terms of penalties, the maximum penalty is proposed to be imprisonment of up to 20 years and significantly enhanced penalties for companies of up to $15 million. There's some fairly significant uplifts in terms of penalties at the moment. The other important aspect of the bill is that industrial manslaughter offences will not be subject to a 2-year statute of limitations, as are other offences. What's interesting and really makes clear the aim of the bill is that if you do get charged with this offence, the judge is given the option of finding in the alternative that the person, the PCBU, is guilty of a category 1, 2 or 3, so they're the current offences. If they're not satisfied that the person charged is guilty of industrial manslaughter, but is satisfied that the person is guilty of a lower tier offence under the Act. So what that does do is gives the judge the option of, if you're charged with this new proposed offence of industrial manslaughter, the judge is not comfortable you've reached that offence, they can then find you're guilty of either a category 1, 2 or 3. So it gives them a range of options in terms of findings. What that basically means is that if you're charged with the offence, if you're found not guilty of that, that's not the end of that. So what will happen in other criminal matters, for instance, if you get charged with murder, if you're found not guilty, that's the end of the matter. Whereas here, what they're doing is they're giving the option of the judge to make sure you're potted one way or another. So basically, if you're not found guilty of the most serious offence, you can be found guilty of the lower offence under those proposed reforms. So that's obviously some significant changes proposed to the Work Health and Safety Act, and it's expected that those changes will be made shortly. In terms of some of the other trends we are seeing in our practices, we're obviously facing generally some labour shortages. We've got inflation that seems to be out of control at the moment, and that is putting a fair bit of wage pressure onto the economy. This was acknowledged last year by the Fair Work Wage Review and led to some increases that were some fairly significant increases. So as we know, the national wage minimum increased by 5.2%, with award rate increases by 4.6%. So what this meant is a national minimum weekly wage of $812.60 a week. That's an increase of $40 a week, or if you look from an hourly perspective, an increase to $21.38, which is an increase of $1.05 per hour. These increases, of course, commenced in the middle of last year, and the Fair Work Commission is in the process of considering its position for this year's wage review. Our expectation is that there will be a similar 5% increase this year based on where inflation is, the cost pressures, and the current aims of the Act that the Commission must consider in terms of that wage review. That increase will, of course, start in the middle of the year. Turning now and just finishing off in relation to claim trends, what we're seeing. Again, that long-term trend of the individualisation of the workforce is consistent with the claims trends as well. So what we are seeing a lot more of is individual claims in areas such as underpayment of wages, unfair dismissals and general protections claims. We're not seeing a lot of collective type disputes such as industrial action and the like. An unfair dismissal application remains the employment claim of choice for employees in the private sector. So if we go to the Fair Work Commission's annual report, that indicates they're dealing with about 30,000 applications a year. Of those, almost half were unfair dismissal applications. So it's pretty clear that that is the claim of choice, remains the claim of choice for employees. You might remember going back a few years, there was, when the bullying provision was introduced in the Fair Work Act, there was a view that there would be a rush of bullying applications. That certainly hasn't. And as I say, unfair dismissal applications remain the application of choice. Historically, applications would often be represented by their union or more recently by a labour lawyer. A recent trend that we've certainly noticed is that a large number of applicants who commence unfair dismissal applications are self-represented. People have the view they can do it themselves, and you can through modern technology. It's very easy to lodge an application which can be done online at the Commission these days. In response to this and the Commission having to spend a large number of resources on assisting self-represented applicants, that includes businesses representing themselves as well, it's introduced its workplace advisory service, which seeks to connect both workers and employers with lawyers who can assist and advise them in relation to the application. Basically, the Commission is trying to get assistance through lawyers to help them deal with this large number of self-represented parties before the Commission. My observation is the further recent trend seems to be an increase in the number of workers' compensation claims for psychiatric illness, particularly in relation to disciplinary action taken by employers. And that seems to be happening earlier in the process. So whereas if you go back, say, 5 years, you'd expect that to happen at the termination point. Now, as early as a meeting to discuss an issue is a point in time where an employee may be considering lodging a compensation claim, and obviously the employer and their insurer having to defend those applications at that early stage. So that's all I wanted to say in relation to claim trends. But I'm happy to open it up to questions in relation to anything I've talked about today. Yeah. Sure. Well, that domestic violence leave has now been introduced as a national employment standard. So that is now part of the NES. And effectively what that means is that an application can be made for that form of leave by an employee in circumstances where they are the subject of domestic violence, and they can get leave in accordance with the NES situations. That's coming off the back, of course, of that being introduced for awards, but now it's part of the NES, so it's an entitlement. questions?
And I'm not sure if you covered it
Sure.
a bit late. The pay secrecy, do you have to amend existing contract if there was a clause in there, or is it just new contracts moving forward?
I think it's appropriate to review existing contracts and roll out existing contracts. One way, in a practical sense, in terms of resolving that situation, is obviously not seeking to rely on pay secrecy provision. So what the law has do is they create a workplace right for employees to be able to talk about their pay. So in response to that, an employer can't take any action anymore, and that's how the pay secrecy provisions operate. And it may well be that you wait till, say, the end of the financial year when you're reviewing wages, such that you're rolling out new contracts and obviously excising those terms from the contracts at that point. So that might be the practical way to deal with that issue. Okay, well, if that's all, I'll thank you all for coming in this morning, and I hope you enjoyed the talk.
Thank you.